Why don't you use the mic? Item number 13.
Yes, item number 13, my lord.
When do you want?
After 1 week,
Okay, after 1 week. All right.
please.
Your Lordship, I beg to mention item number 21.
Yes.
Your Lordship, the leading counsel is undergoing a medical treatment due to which he couldn't be able to attend us.
After?
After 3 weeks.
After 3 weeks, 21. Yes.
Obliged.
Lordship, I beg to mention item number 15.
Yes. What is the mention?
This is the application number 482.
What do you want?
Lordship, actually, as per order 14/9/2023, the petitioner was directed to take step upon respondent number 5, but unfortunately, there is service could not be taken. So I may be allowed to take fresh step.
Then we'll list it after 4 weeks. After 4 weeks.
Deeply obliged.
For that, no order is necessary. There is earlier order.
Lordship.
May I please, Lordship? I beg to mention item number 40,
Yes.
CRP 48/23. As per the last order, this honorable court has directed the
You
petitioner,
want an adjournment?
yes,
How
For-
much time?
for 1 week.
Okay, 1 week. After a week.
Yes, deeply obliged.
Your Lordship, at the outset, Your Lordship, I have objection on non-implement of the informant, Your Lordship. It's a revision petition, criminal revision petition.
Informant is a necessary party.
Yes, Your Lordship, as per the High Court rule, Your Lordship, in the revision and even under application 482, an appeal against acquittal, Your Lordship, it is obligatory for the petitioner to implement the informant, complainant, victim as case may be, Your Lordship.
Which
The-
rule?
Your Lordship rule, this one, Your Lordship.
Yes.
Chapter 11, Your Lordship, criminal business 1A.
1A.
Yes, Your Lordship. It's a obligatory for the appellant petitioners to implement the informant, complainant, victim, or the accused person as case may be as respondent in the appeal filed under section 378 of the Code of Criminal Procedure or under proviso to section 372 of the code, and also in the revision petition under section 397/401 or in the petition filed under section 482 of the Code of Criminal Procedure.
My lord, as per my understanding, my lord, the improvement is the police personnel, my lord. So he may be not necessary as party.
Police officer can't be informant.
He can be improvement, my lord. But is it not necessary to implement as a party?
Not necessary.
Yeah, as per my understanding.
Had Mr.
And those, my lord.
M. Doshi, learned counsel for the petitioner, and Mr. T.H. learned APP for the state. This is an application under section 397, read with section 401 of the Code of Criminal Procedure 1973, praying for passing of the order dated 13/7/2023, passed by the London Special Judge NDPS Bomdila in NDPS case number 14/2022. Wherein charges against the petitioner has been framed under section 20B2C of the NDPS Act. So, Mr. T. Ete Lanet additional APP by referring to chapter 11, rule 1A of the Guwahati High Court rules permits that in an application filed under section 397/401 of the Code of Criminal Procedure, it is obligatory for the appellant petitioner to implement the informants within the informants, complainants, victims, or the accused person or persons, as the case may be. So, he therefore submits that since this revision petition under section 397 read with section 401 of the Code of Criminal Procedure has been filed without adding the informants or complainants or victims or accused person as a party respondent, the instant revision petition is not maintainable. So, Mr. G. Dozy,
M. Doji.
Lanet counsel for the petitioner on the other hand submits that when the informant is a police officer, or constable, officer, it is not necessary for the petitioner or appellant, as the case may be, to implement the informant as party respondent under rule 1A. So under chapter 11, rule 1A of the Guwahati High Court rules. So, chapter 11, criminal business, capital A dash general, rule 1A reads as under court. From reading of the rule A of the chapter 11 of the Guwahati High Court rules, it appears that in an application filed inter alia under section 397/401 of the CRPC, it is obligatory for the appellant petitioner to implement the informants or complainants or victim or the accused person, as the case may be, as respondents in the appeal or the revision petition. So, a careful reading of the rule 1A of chapter 11 of the Guwahati High Court rules, it does not appear to make any distinction about the informant, complainant, victim, accused person it does not make distinction. Did I say between? No, it does not make distinction between. It does not make any distinction regarding the informant, stroke complainant, victim, accused person being a police officer or otherwise. So, in that view of the matter, I am of the considered view that in an application filed under section 397/401 of the CRPC, it would be necessary for the appellants of petitioners, as the case may be, to implement the informant or stroke complainant, victim or accused person, as the case may be, irrespective of the informant, stroke, etc., being a police personnel or otherwise. So, since the instant revision petition has been filed, not in conformity with the chapter 1 criminal business, a general rule 1A, the same is dismissed.
Online.
My lord, this is the revision petition, my lord. Challenging, my lord, order passed by Deputy Commissioner Pasigat entitled suit number 02/2011, my lord. My lord, here the title suit has been dismissed basing on the res judicata. Whereas, Your Honor, yeah, my lord, I am not a party in the earlier Kebang. My lord, may kindly turn page 73 of my.
Just a minute. Yes,
My lord, page 73 is the summon issued by the type copies, my lord, 74. 74, my lord. Here in left corner, my lord,
page
which
number,
page 74, my lord. Type copy.
74 is the impugned order.
No, my lord, this is the Kebang, my lord. Kebang decision.
What are you challenging here?
Challenging, my lord, here in the 74 Kebang decision, my lord, here the Mebo Moru Kebang Society versus Mebo Village Kebang. This is the disputing party, my lord. Page 74 left part, my lord. Mebo Moru Kebang Society versus Mebo Village Kebang. I am not a party in this case, my lord. But my lord, the impugned order passed by Deputy Commissioner, that is, my lord, is appeared on 71, my lord, 71, my lord. My lord, operative part is that, my lord, the last paragraph is, get it, my lord.
Yes,
And the fact in brief is that petitioner filed a title suit on 29/12/2000 in court of Deputy Commissioner. The petition annexed the Kebang decision of 30/11/2011 and claimed that land occupied by petitioner is individual and other person have no vested right to interfere over the land of petitioner. After carefully going through all documents, record 11 materials, while taking into consideration the provision of law in force, this court is of view that Kebang decision that 30/11/2011 came into finality. The title suit filed by PD involving same subject matter, same party is hit by law of res judicata. The same party involving same party was decided by the competent authority, Kebang, Your Honor, my lord. A thing on matter that has been finally judicially decided on merit and cannot be litigated again between the same party. My lord, in order it is written, but in Kebang decision, I am not a party. Therefore, my lord, the Section 11 is not attracted in this case. And moreover, deputy commissioner has no more jurisdiction, my lord, to dispose of the matter.
Do you have any interim prayer?
Yes, my lord.
What kind of interim prayer?
My lord, to stay the operations of this imperial order, my lord.
What is this order? Actually,
Actually, my lord, this is has dismissed my title suit, my lord. This order.
it has dismissed your title suit
Yes, my lord. While hearing the IA,
on an interlocutory application filed by the opposite party.
opposite party.
Title suit is at which stage?
My lord,
Title suit is at which stage?
title suit was at, actually, the stage was not mentioned. Actually, as per the directions, we have
It is
filed
pending before whom?
deputy commissioner Pasigat.
Deputy Commissioner
Deputy
can take up title suit.
Yes, yes, my lord. Neither he transferred the matter to the civil court nor take up the matter. That's why,
Deputy Commissioner can take up title suit.
actually, my lord, before we file, my lord,
Ask Mr. T. Taki,
yes, my lord.
from the counsel for the petitioner. Issue notice reasonable in 4 weeks. The steps for service of notice upon respondents be taken by the register post ready as well as the usual process within a week. Till the returnable date. The order dated, the impugn order dated, page 71.
Yes, 17/8/23.
17/8/2023, passed by the Deputy Commissioner Eastern District Pasigat in IA number 02/2023, entitled to number 2/11, 2011, Alok Tying versus Anok Tying and 14 August at page 71. Shall remain state listed after 4 weeks.
May I, my lord, sir? This is a bill application number 97. In the instant case, this bill application is being filed by the elder brother of this alleged accused, who is in judicial custody for last 38 days. So the brief fact is that based on the FIR filed by,
Did you approach the court below?
This is a successive bail application.
a subsequent bill application before this,
It was rejected by this court also.
yes, rejected in the sense there was no that
Lordship will find it.
bail rejection order is in 27.
Huh?
Page number 27.
Yes.
Bail rejection order is there. And in bail rejection order, it was rejected based on the price by the public prosecutor that Papu Yadav case, which is for heinous crime. But this is for receiving a stolen ornaments. So in the instant, before this bail order, means rejection order, if you, my lord may go to page number 30, there is a, in para 14, this lordship has clearly stated that, however, the alleged accused is allowed to get medical treatment under police protection to any mental hospital like TRIMS or Mitpur. So subsequently, after this order, this superintendent of Julie Jail has taken this alleged accused to the mental hospital.
See, this successive bail application is to be placed before the same judge.
Yeah, my lord.
Yes, who has rejected the bail? Yes, Your Lordship. However, if there is, the judge is not present at the bench, Your Lordship can take up this matter.
What about this video conferencing? I think there was some notification.
I'm not well aware of. With regard to benches, Your Lordship,
There is one notification. Ah, this has been rejected very recently.
yes, Your Lordship, 19th of September.
There is notification.
Yes.
It is to be done via video conferencing.
No, in fact, that notification, video conference, regarding video conference, is not expected. if in the absence of the judge, other judge, rejected the bail application, then it's not available in mediation,
But I have seen one notification, not necessarily a bail,
Yes.
some review or something like that.
the same.
Same notification. Where is that? Let us see that notification. Can you find out? I think you can get it from judicial section. Ah, yes.
So there is a change in the circumstances.
Ah, what is that?
So change in the circumstances is that there's a health status report subsequently on 27, that's annexer H 32 to 34. And before that, my lordship may turn this page number 31.
All right, we'll take it up after some time. Let us see that notification. Hmm? Oh,
Due to agency, I have mentioned this matter in group number 1.
yes.
This is a poetical application matter for getting custody of the vehicle. And I filed this petition matter due to recent development in one of the judgment that during investigation 451, 457 is not applicable.
Mike.
But during investigation matter 451, 457 is not applicable. Whereas matter the 482 petition is applicable matter. Here, my vehicle has been seized by the police, madam.
Who is notice?
Yes, madam. Report may be called for, madam.
Report or what? Record?
A report may be called for from the police investigating
from-
officer. From Rupa Police Station, madam.
From Rupa.
Rupa, yes, madam.
What kind of a report?
Madam, whether madam, the vehicle is required for investigation or not, madam.
Let her take instruction. You take
Yes, madam.
instruction. Her Mr.
As
S. Botako. On the council for the petitioner and he's in it. Representing, what the respondents?
He is a police
APP.
officer, madam. He is the officer in charge, madam, of the police, Rupa Police Station.
APP representative. You should notice. Returnable in 3 weeks.
After 3 weeks, Your Lordship.
But can you fix on 13, madam, because my vehicle is,
13.
yes, madam, on 13 of.
Your Lordship, in that case, a scan copy would be appropriate.
Only
because-
report is required, madam, whether the vehicle is required for investigation or not, madam. Because to my knowledge, madam, confiscation proceeding has not yet started, madam.
No, what kind of LCR? Investigation is going on.
Yes, is going on, madam.
Yes.
Only, madam, the report is required, madam, whether my vehicle is required for investigation or not, madam.
The fact of the case is that 188 gram of cannabis were found from the vehicle of the accused, Your Lordship.
Ah.
So now they are claiming for the release of the vehicle during investigation. That's
Now here, say, madam, the petitioner is a, madam, the accused person who are implicated
So
in
you
the,
can obtain instruction whether the vehicle will
Yes.
still be
that
required.
must is required.
You should notice. Returnable on 13.
Yes, madam, on 13, madam,
Okay, 13 of
October.
October.
Yes, madam.
On which date? Then APP shall obtain instruction. Including whether the seized vehicle would still be required by the investigating authority for further investigation of the case. Please take a look.
the
Number 3.
Okay. Yes.
May I, Lordship?
Hmm.
So,
What is the change in circumstances you said? Health ground.
health ground, yes.
Let us see.
So, before that, if may I apprise this Lordship regarding the background of this case, how that health issue has means abrupt up in this instant case.
Regarding your receiving of a stolen property.
No, there is allegation that she has received stolen property. She alleged accused deals runs a shop called this local beats.
But you are seeking bail on health ground.
Yes,
So stolen property has nothing to do with your health.
yes, that's why.
Yes.
Now, this alleged accused was arrested on 26. That's in page number 18 and 19. That's arrest cum inspection memo. Page number 18 and 19. That one is typed copy. Page number 18.
Yes.
And subsequently on 27, there was a custodial assault. And that was custodial assault was done by one male suspended officer in Naharlagun PS. So same was observed and inquiry order was passed by the learned judicial magistrate first class UPN. And that's annexed here in Annexer D, that's in page number 20 and 21. Page number 20 and 21.
Yes.
That the order dated 31st/08/2023. So subsequently, because of that, there was a health issue, and that medical officer of Central Jail, Julie, District Jail, Julie, has examined this alleged accused and diagnosed she's suffering from schizophrenia and referred to this Naharlagun TRIMS Hospital. And subsequently on 12th of September, Naharlagun TRIMS has also referred and diagnosed as psychosis. So they referred to this Mitpu Mental Hospital. So meanwhile, just to weaken this custodial assault, this police officer, they are just dragging this alleged accused in different cases that related to stolen property cases. And just now, alleged accused has been shown arrest by the Doimuk PS just now. So there are 4 cases recently, and now it's a 5 case. We're just to harass or just to weaken the custodial assault. They are just dragging this alleged accused in different cases, just for the sake of this investigation. And Sam has been apprised to the learned judicial magistrate first class that.
But we are now concerned with only one case.
Yes.
Which is that case?
That's 136 Naharlagun PS.
Let us confine to that.
Yes. Yes, Lordship.
Yeah.
So in this case, if you turn the health status of this page number 31, where the head of this mental hospital, Mitpu, has clearly suggested for this medication and everything. Now she is in medication, but there is a advice from that may admit with 24/7 with security at the mental hospital. And it's not harmonious situation for this alleged accused to be there in judicial custody at present. And one of the interesting is that right now she's not there in judicial custody, just at present situation.
What is page 31, which you have pointed out?
Page 31 is a prescription slip. Prescription slip, my lord, may go in last para regarding for admission.
Yes.
May admit with 24/7 security and allow family member after being diagnosed. And there is a medication slip. And subsequently, page 32, there is a forwarding letter from this superintendent of Julie Jail to this judicial magistrate on 27th of September 2023. So at present, subsequently for last 38 days, she is facing this mental health issue, and same has been diagnosed by not only by one medical officers, by Julie Zell medical officers and TRIMS medical officers, and mental hospital Mitpu medical officers, that psychiatrists. So their prescription that's in page number 35.
Hmm.
In 35, those are the prescription right now she's taking.
Hmm.
So it's everything is there in this.
No, your health status report is at page 34.
Yes, it's
You read the remark part.
yes, my lord, sir.
You read the remark part.
Yes, the inmate Ray Amag is conscious,
Slowly,
cooperative.
slowly. Yes.
Yes, that's part. Remark. So well oriented to time, place, and person at the time of examination. She is provisionally diagnosed to have a psychosis and under medication from a psychiatrist.
The inmate so and so is conscious, cooperative, well oriented to time, place, and person at the time of examination. She is provisionally diagnosed to have a psychosis and under medication from a psychiatrist. She seems to be okay.
My lordship, that's why, according to this 27 report, she is in medication. So
She is conscious,
yes,
cooperative,
yes, my lords.
well oriented to time, place, and person. Then what else?
That's why. But thing is that subsequently this police, they're just dragging in other cases. Just
Other
taking,
cases,
yes,
we
yes.
can't- we can't
my
take cognizance of it. What to do, yes, sir?
Yes, your lordship will see that on the previous bail application, your lordship, the ground of medical was also taken and the court has also
Same-
taken consideration.
Same status report was.
Yes, and subsequently after the rejection order was passed, there was a specific direction that her health condition may be taken care by the police. This report is just an update of she already going for the medical treatment, your lordship. This is not a new ground.
26th September.
If your lordship,
But we don't find anything wrong in this health status report at page 34.
My lordship, that's why at present, if lordship may turn to this page number 31, where means the medical officer of the Mitpu has clearly stated that may admit, reason is that she need atmosphere where there is a proper care is there. And because of this, at present, the investigation is also a hampering. If she is not stable, how that investigation will
your
be?
lordship, if I may, your lordship.
See, that prescription is of 21st September.
Yes, and bill was rejected on 19.
Health status report is of 26th September. Subsequent to that,
Lordship.
other day, a bail application was moved by enclosing a certificate from TRIMS doctor
Yes.
referring for some ailment to Nigrims at Shillong. We called a report from the TRIMS.
Yes, Lordship.
Then report came that for which the patient or the accused were referred to Nigrims, that treatment is very much available at TRIMS, and the reference was made at the insistence of the accused. So such are the reports we find. What to do, Miss?
Yes, your lordship, lordship, and this matter, even otherwise in their prayer, your lordship, there is a specific prayer there in making that the CD may not be called and the bail application may be entertained, your lordship.
Hmm?
In item number 4, your lordship, if you oblige.
Item number 4.
Yes,
That,
This is,
that,
this is
that's-
item number 3.
yes,
this item number.
yes, item number 4 is,
That is 4.
yes. This is item number 3, 136.
4 is the accused,
Is the
is the
same.
same, your lordship, the complainants are different.
So that's for bail
Okay.
for Papu Hill PS case.
Case register is also different.
Yes, your lordship.
So originally in the FIR, there is nothing like this. She run the shop where they came and they just seize all the, means her personal ornaments and vehicle also. And it's still that seizure list is not there.
In item number 4 also,
The same medical, previous medical reports has been annexed, your lordship, not the present one.
well, again, examine, what is the stage of the investigation?
It's been 38 days.
Your lordship,
Any idea? No.
the bail was very recently been rejected.
When was he
your lordship.
arrested?
She was arrested on 26/08. 26,
September,
it's
October.
for 38 days now.
Let us see the case diary again.
Yes, your lordship. Thirteen October. Both.
Highly obliged.
4 also. Call for the case diary fixing 13 of September, October.
So in this case, my lord,
Hmm.
other side, they have raised the issue of maintainability.
Hmm.
So let them begin how this revision petition is not maintainable.
This revision challenges what?
The impugn,
Against the Kewar decision. There's a provision for appeal. Instead of going for appeal, they prefer the civil revision petition. So that's why we raise the preliminary objection that this civil revision petition is not.
All
When
right.
there's an appeal provision under the statute.
Where is the Keva decision?
Mother Kewar decision is a page 21. The Kewar decision is page 39. 29. Yes, yes, yes.
Page 29.
Kewar decision. Sorry, ma'am. Kewar decision, page 20. ma'am.
Hmm?
Page 20.
20.
Yes, ma'am.
Is a notice. Huh? Affidavit? You are referring to affidavit?
Sorry, sir. Sorry, my lord. I just somewhere is missed. Sorry, it's 29.
29.
Yes, yes. Thirty-nine of civil revision.
This revision petition is under CPC.
Under, yes, 227, read with 151 of the CPC.
Hmm. 151.
Yes. Inherent under.
227 is for without jurisdiction.
without jurisdiction.
Okay, without jurisdiction, yes.
My lord,
Your contention is Keva is without jurisdiction.
Without jurisdiction, and the ADC Nyapin could not have been participated in the, indirectly participated in the mail proceeding.
Okay, all right. Yes,
My lord, it is not a case that this has been passed or order has been passed by the ADC. In fact, it has been passed by the Blaze Authority, by the Inter-Blaze Authority.
let us see.
And
And the dispute is what? Land dispute?
Land
it is
and water.
land and
Okay. Yes, let us see. Who has passed this order?
Passed by all Nyaping Welfare, Gangbra Welfare Association.
All Nyapin Circle Gaonpura
Yes, it's a
Welfare
collaboration, madam. It is a group.
Association.
Yes, interblaze, madam.
This is a registered association.
My lord, it seems, yes, madam. Yes.
Huh?
For a group, my lord, the Gampura, madam, they are.
A registered association of Gambura.
My lord,
How does it have a jurisdiction?
my lord,
Is it a court?
my lord, this is called, my lord, it is the association, it's a group, man,
Yes.
group, my lord. Now, group, my lord, you see, if you go by, my lord,
This association derives authority from which statute?
Society Registration Act.
No. Huh? Okay.
my lord, my lord, this, basically, this is a group of the blaze authorities, my lord. Now, under the Arunachal Pradesh Civil Code Act, my lord,
Yes.
the particular, my lord, the blaze authority and customary court has not been clear manner, it has not been defined. It has been, my lord, I'll just come to the definition part, my lord.
This is the most controversial area.
My lord,
Lawyer's paradise. Huh?
my lord will see
This is
section 2, my lord.
the legislature has created a lawyer's paradise. Yes.
My lord, section 2B, my lord.
Yes. To be.
Civil court means a court of district judge, a court of additional district judge, a court of civil judge senior division, a court of civil judge junior division, or a customary court, including blaze authority by whatever name called under Assam Frontier Administration Justice Regulation 1945.
Yes.
Now, D, madam. Customary court means court of traditional council or authority of blaze indigenous to the state by whatever name called, and includes the court of blaze authorities and section 5 of the Assam Frontier Administration Justice Regulation. Now, it includes, madam.
This Gaonpura association comes under which provision? To B or D?
Madam, it since the customary court, madam, it is been, madam, by what manner, by any manner,
Hmm?
whatever name it may be. Now, whatever recognized, madam.
No. Yes. It comes under D.
Yes, madam.
Okay. Yes.
Includes blaze authority, madam, including appointed under section 5 of FR.
Are you sure it comes under D?
Madam, my humble understanding, because
No.
it says,
Once
yes,
once you say so,
yes, madam.
then we will start reading D.
Yes, madam.
Yes.
Customary court means a court of traditional council or authority of blaze or indigenous to the state by whatever name called,
What is okay?
whatever name called.
Yours comes under traditional council or authority of a village indigenous to the state by whatever name called.
Yes,
Which one?
Authority of blazes, more than one place, madam. This,
So according to you, it is an authority of a village
yes,
indigenous to the state by whatever name called.
yes, madam. It's a group, this association, madam, the member is the group, it is the group of the blaze authorities, madam.
How you will show it?
Madam, this, the association, my lord, its a member is Gangbras, all Gangbras, my lord. Nyaping Circle Gangbura Welfare Association. Now, It's member, my lord. The member of this association is all Gangra.
You have filed affidavit.
Yes, my lord.
All the respondents are represented.
Yes, I represent national too, my.
You have also filed affidavit.
Yes,
We'll admit it and proceed to hearing.
Okay.
Since there is a stay order. This is an area. You should be very careful. Heard Mr. K. Tama, learned counsel for the petitioner. Mr. T. Tama, learned counsel for R1 and M. Bazi for R2. The counsel for the respondent has submitted the respondents have filed their response. So. Since all the parties, since the respondents are represented by the respective learned counsel and the responses have been filed, let this revision petition be admitted for hearing and listed in due course. Interim order for service will continue till the next date of listing.
Highly obliged.
All right.
Item number 6.
Yeah. Yes. This is the RS, regular civil division. Here we have filed the appeal along with the substantial question of law. Then as per the latest order that we shall have to modify, make the correction to the substantial issue. For that I have filed. The order was passed on 16/8/2023.
Yes.
16/8/2023. Here, the substantial questions of law proposed by the appellant in paragraph 19 of the memo of appeal lacks material particulars such as descriptions of the unregistered document mentioned in serial number such and such, the term and conditions of the agreement mentioned in serial number such and such. So on the basis of this order, I have filed the rectify the defect proposed substantial question of law of the regular first appeal in terms of order dated on 16/8/2023. Now, the proposed substantial law involved are as follows. Whether the unregistered document dated on 8/3/2010
match in between appellant and respondent has completely lost its credential. Whether the witness, Sri Palomu, DW4, who is the party to the agreement dated on 10/8/2010, e.g. defense exhibit number 3 can depose against the term and condition of the agreement. The term and condition are as follows. That on March 2010, the second party and Sri Tabatakar enter an agreement with the first party to borrow a sum of rupees 5 lakhs only with interest of 5% per month from the first party. That the said amount of rupees 5 lakhs was borrowed from the first party by the second party and Sri Tabatakar for purchasing land at Helipad sector. C. That the second party and Tabatakar, who had agricultural land at Helipad, had no permanent parts road to enter the said agricultural land. D. That both the second party and Sri Tabatakar has taken the loan from the first party for purchasing land so that they can use and permanently without any hurdle as part oblique roads to enter their agricultural land. E. That the loan which was taken by second party and Sri Tabatakar from the first party was not paid yet because Sri Tabatakar, who completely denied to pay any amount to the first party. F. That now all the burdens come to the second party for payment of rupees 5 lakhs with interest of 5% is in total 6,25,000 only. G. That Sri Tabatakar, who completely denied to pay the amount which was invested to purchase the land for the part road, shall no right to use the part road from the today. A. That the second party shall pay the entire amount of rupees 6,25,000 to first party. And that the first party shall give the receipt to the second party as acknowledgement. J. That the land are measuring 26,880 square meters, 2.688 hectares of the land. Whereas in the evidence DW4, Sri Balamu deposed in contrary to the agreement dated on 10/8/2010. It stated that money was taken on loan by Srimati Tessimania, appellant, herein instead of Sri Tabatakar respondent.
Yes.
Then these are the term and condition. Term and condition. Now come to the second. Whether a witness, Sri Balamu, DW4, can be allowed to give evidence contrary to the content of the document agreement dated 10/8/2010, executed in between the appellant and Sri Balamu. Method is very simple. Now, both of us made an agreement. Whether at the time of giving evidence, can I say, no, this agreement, there is no dispute about the signature. He is accepted and repayment and receiving of money is also not not disputed. Yes, I have paid 6,25,000 to the Balamu. And as per the term and condition. Now, question is that whether he can depose against the term and condition given in agreement in the court.
Signed by him.
Yes,
What do you say? According to you, he cannot.
he cannot. My
What is-
point is that
Where is the law?
law.
Yes, that he cannot depose against the terms of the agreement.
Yes,
Where is that?
Evidence.
It is a settled law.
Settled law.
Huh?
It is a settled law.
Then if it is a settled law, then where is the question of substantial question? It is a
But-
settled law.
But
Huh?
trial judge,
Yes.
trial judge completely ignored the term and
Let,
condition.
let us see your decision.
Huh?
That one cannot depose against the agreement signed by him. You have basically framed, I think, two questions, Mr. Tama, isn't it? 2 and 3 is the same.
2 and 3 is the same.
2 and 3 is same. One is, let us begin with one. What is this? Unregistered documents. What is this document?
And para 15,
15.
15, I think.
Yes, yes.
Oh, it's very old.
What was this agreement dated? What is agreement date?
Agreement,
10/8/2010. Yes.
2010 agreement.
And what is this unregistered document 8/3/2010?
There are two documents. One was agreement made between appellant and the respondent.
That is which agreement?
That agreement
Dated?
two agreement. One agreement was, yes, an agreement was made on 7 March 2010. Second party and Sri Tabatakar. That is another agreement made between Tabatakar and that is unregistered. But it could not be exhibited. But the trial was going on. At the time of need of the argument, final stage, the party has given us the photostat copy. Then I produced it before the CGM that it has been recovered from the possession of the present effect. Then it was rejected because of due to need of the time. And if it is accepted, it may take time. Then after that, I have filed before the High Court as a revision petition. Then it was not also accepted. Then after that, again, that is under order 8, we have filed. That is before the appeal argument. Then it was unregistered. Then again, after appeal, I filed as per order 47 rule 27. I have filed it to use the same document as an additional document in the appellate steps. Then that appellate step prayer was not considered. So considering that is understood. There are two agreements, and in one agreement, 10/8/2010, we have no dispute. There is no dispute.
What is this 10/8/2010 agreement?
This is the agreement made between Balomuk and the present appellant.
Appellant and who is this Balomuk?
Balomuk is DW4.
What is the dispute? What is the dispute between the parties?
Regarding land,
Who is this Balomuk?
Balomuk is the person from whom we borrowed the amount,
Borrowed the amount.
and that amount was used by the respondent, and I was the guarantor.
Who borrowed money from this Balomuk? DW4?
Respondent.
Okay, respondent.
And
You are the guarantor.
I was the guarantor.
Okay. All right. Then what is this 8/3/2010 document?
10/8/2010 document.
Before that, 10/8/2010 document is a money borrowing agreement between Balomuk and the respondent.
The present appellant. I being the guarantor, I repaid the money. The loan taken by the response.
From Balomuk.
I have repaid the Balomuk as a guarantor because the amount was taken from Balomuk.
Let us see the document itself. Where is the document? 10/8.
Document.
10/8, yes.
Yes.
10/8/2010 document.
Come to the. Yes. Come to page 200.
199.
199.
This is an agreement between Balomuk and the respondent.
Yes.
No. Balomuk and you. Is not it?
Yes,
Ah.
I am not the party.
Okay. So, all right. This is an agreement between the Balomuk and you, is not it?
Yes.
Respondent has nothing to do with this agreement.
Here we have mentioned the name of the respondent because respondent has refused to repay the amount, loan amount, borrowed amount. For that, the responsibility come to me.
By this document, what is this agreement? At page 199.
This is the agreement made between Balomuk and the present appellant.
Yes. What is the agreement?
Here, term and condition. Therefore, this deed witness as follows: that on 7 March 2010, the second party and Sri Tabatakar, the present respondent, entered an agreement with the first party to borrow a sum of ₹5 lakhs, only with interest of 5% per month from the first party. Now, that the same amount of rupees 5 lakhs was borrowed from the first party by the second party.
All right, all right. I think no nomenclature can be given to this agreement, is not it, Mr. Tama? This is an agreement of very,
Behind my back,
just, all right. all right.
purportedly behind my back, this is executed. Kindly, my lord, come to
No,
the
it's-
evidence of this TW4. What he is saying about this document, my lord?
All right, then let us come to this 8/3/2010 document.
10-3.
Hmm.
10-3.
Not 10/3, 8/3.
Correct. 10-3. Huh?
8/3, Mr. Patil.
Ah. It was not exhibited. It was, the original document was handed over to us after judgment. After judgment. Huh? Yes, come to the page 272.
Hmm?
272.
272.
Yes.
Yes. This is mortgage.
This is here in the title. It is written deed of simple mortgage.
Yes.
But when we see the content, what is mortgage? It is a conditional sale. Conditional sale. If we go through the content of the agreement, it is not comes under the definition of simple mortgage. Now, I'll read out the condition. I, Sri Tabatakar, son of Tabatisi, resident of Model Village, POPS Naharlogo, District Papumpare, Orunachal Pradesh, have received a sum of rupees 5 lakhs only for road construction from Sri Balomu, son of Sri Balotami, a permanent resident of village Via Balo, P.O. Gangte, P.S. Palin, District Kurumkume, Orunachal Pradesh, and presently residing at Dam site Naharlogo, P.O.P.S. Naharlogo, District Papumpare, Orunachal
Here,
Pradesh.
respondent is the mortgager. Who is the mortgagee?
Here, actually, mortgage is, it should be between Tabatakar and the present appellant. But here in the case, it is like a condition is not come under the simple mortgage. Mortgage is that made between two persons. But here in the case, it becomes three because money is taken from some other person. Because in the case of mortgage, I'll give the money, the person who I become mortgagor, and if the person who has received it. it is
Mr.
mortgage-
Tama, on these two questions, we will admit it. So very peculiar documents are coming up. Mr. Patil is arguing the case like we are hearing the appeal. Today, we are just for framing of a.
No, my
Questions of
lord. May I have my objection in
Ah.
that case? Kindly come to my written objection that is on record, my lord.
No. As per
Let me-
law, court should formulate the substantive questions of law. After, before formulation of the question, substantive questions of law, how he argue that?
Okay, just a moment. Let us see,
And he is jumping.
see, then let us take up one by one. You have basically two questions. You address this court, how the question number one framed by you is a substantial question of law.
Huh?
How the question number one framed by you is a substantial question of law. Let us restrict the arguments and consideration by this court to that limited extent.
Yes. It become when the things become.
You first read your question number one
Yes,
and you address this court that question framed by you is a substantial question of law under section 100 of the CPC requiring determination by this court.
To the satisfaction of this honorable court.
Yeah. Now, questions of law, substantial question of law.
Let us be precise.
Yes, precise. Whether, uh, uh, whether a witness, Balamut, DW.
No, no, that is number two, mister.
Huh?
That is your question number two. Question number one,
Question number one.
let us begin with the beginning.
Huh.
Yeah.
Whether the unregistered document dated 8/3/2010 made in between appellant and respondent has completely lost its credential. Now,
What kind of a document you have not specified?
that I have annexed in the appeal petition, that is the agreement made, that is deed of simple mortgage, that is page 272.
Yes,
Now, this we have not, we are not placed it at the time of trial. I have produced it at the appellate stage, in the appeal. Then this petition was, the appellate petition was not accepted. Now, again, I raised this question here in the second appeal. Now, it is a duty of the court to see that whether it is a false, whether it is a false document, and after going through the content of the document, if court feel it that it is a document which is very much relevant to the subject matter of the dispute. And
duty of which court? Trial court, first appellate court,
Yeah.
or the second appellate court?
no, now I have come to the appellate stage. It is the all court, because I have submitted that.
All courts, it is the duty of all
No,
courts.
no, it is in the appeal stage also. It can, because I was not produced this document before the
Trial
trial
court.
court.
Yeah.
And original document was recovered after judgment, handed over to the advocate. Now, in the appellate stage where I have produced it, it is a duty of the court to see it, whether this particular content of the document is very much related or it is relevant or not. Just to know, and judgment may not be given my favor, but document art should not be rejected before ascertaining the activities. Now, this is their contention is that this document is unregistered document. Now, my contention is that even it may be unregistered.
In
But-
which court it was contended that it is unregistered document?
Correct.
You see, Mr. Patil, if we have understood you correctly, this document, simple mortgage, you did not produce it before the trial court.
Trial court, yes,
Then you produce it before the first appellate court.
appellate court,
First appellate,
first appellate court.
During the stage of final argument,
Oh.
they attempted to produce this document
Okay,
by filing IA. And that IA, it was rejected. In revision, it was come before this honorable court.
Ah.
This honorable court also rejected.
Ah.
Thereafter, again, in the past appeal, they tried to brought that document on record. First appellate court also rejected.
By way of a IA.
Not IA they have filed to bring it on record.
No, you said that this document was attempted to be brought in before the first appellate court at the time of final argument.
No. Before the trial court.
No.
Oh, before the trial court.
Before the trial court, at the stage of justice,
At that
to
time-
assist the court.
At that time,
Ah.
Photo state was handed for us. Photo state. It was at that time. the
Okay.
original was
No,
not
no.
handed over.
Before the trial court.
Trial court.
Photo,
Did you file an IA?
Yes,
in my,
that is,
it is there, they have not filed it, the order of learned trial court, the order of this honorable court in civil
we have
revision,
filed the IA.
everything is there. In my, this thing,
And I
objection.
filed a civil revision. Civil revision petition before the High Court also.
Then
But-
what happened? Then what happened?
No, it
That was
was rejected,
dismissed.
but it was the condition. It was in that there also, that is trial stage. And there are two stages. During trial stage also, you can produce additional document. That condition was rejected. But in the appeal stage also, you can produce the additional document.
I think, Mr. Patil, this will require an exhaustive hearing. We'll do it some other day.
Yes, my lord.
Now.
Either to
Since.
formulate a question or either to dismiss it, because in my, to my humble understanding, there is no
since-
case at all.
Yes, Mr. Patil, since after hearing you for about half an hour, now a fact has come that you had produced it before the
Trial
trial court,
That was not
And
allowed,
now-
revision,
and you had approached this court also. You had approached this court also.
That is in order one.
We will, we
Order
will,
one rule.
we will hear you exhaustively.
There is also problem.
Yeah.
Now again, I have filed one additional document. After giving the revoke order, status quo order, the other party is using the land.
there is no status quo.
I have filed.
And today they have filed, my lord,
No.
additional affidavit.
Additional.
By that additional affidavit,
Additional,
Yes.
I have filed. it.
But
Now,
we can't do anything unless appeal is admitted
substantial question of,
by framing
question
a
is formulated.
substantial question of law.
no, after, now my submission here is this. Whether I made an appeal or what is the dispute? We have,
Huh?
against the order of the appellate court, of the first appellate court, I have come to the second. Appeal. Now, there is no dispute that I have made an appeal. Can the other party take the law in their own hand?
Hmm?
They cannot occupy the land. There is a provision. Order 21, execution, they should file. Before filing of execution, they have occupied the land. That's why this court, after hearing, the successful order was given. But again, the same court has vacated the order. Now, because of that, I have filed today the additional document. Now he is telling the land. Respondent has telling the land. It will invite the multiple of case and it will frustrate the appeal. Even I may go to the higher court after this also. And if the judgment comes in the favor, and if the land is not in debt, if it is occupied by many persons, do you like that thing? Because that is not the way to give the justice to the party. Land will never decay. Land will never long. So during the pendency of the case, both the parties should maintain this situation. Other party is taking the law in their own hand. They are occupying their land. So in that case, a successful order may be given.
See, this court on the first hearing date, status quo order was passed
But
while issuing notice,
yes,
which was subsequently vacated by this court,
yes,
saying that no notice even could have been issued without admitting this appeal by framing a substantial question of law.
No,
Now, today it has come up for
the whole the case was come up.
Ad-
The party is there,
admission of the, yes.
party was there, a notice was issued.
Why did you allow this court on the first day to issue notice? You were a party to that order. It says, heard Mr. M. Patil, Senior Counsel, issue notice. Then status quo order.
Yeah,
That order was not permissible
now,
by this court.
now again I have come with the additional document.
So we'll
Additional document means after the background of the status. quo
so this
they
second
avoid the
this second sets of substantial question of law was allowed to be submitted by you in order to rectify. Even your earlier substantial question of law formulated did not contain any material particulars. So today,
Now, several days come, they always never come to the conclusion. So during that whole time, other parties taking the advantage. And there is a provision, they can go for the filing of execution petition. That is the procedure, but vacating and giving other side advantage to the other. party.
you may challenge that order where the status quo order was vacated by this court.
And that day it was issued, that on which day I formulated the question of. I will give this story. It was the, now till today, the substantial question has not been formulated. This is my second attempt, third attempt. And method is pending. So during pendency, the state should be given.
Why was the substantial question of law not formulated at the first instance?
May inform.
No, the record is here. Why was it not formulated by the court?
That is the duty of the court, and we comply, the court orders. Because court has directed us to give the particulars of the document. I have given the particulars of the document to them.
Then we'll have to hear Mr. Tama. Yes. Okay, we'll hear. Begin with question number 1. Again.
Let us go serial wise. One, I'll reply on one.
But if you have to proceed with the hearing, you have to be specific. You must have object to be achieved in your submissions. Today, we are not hearing the appeal. Today, we are formulating a substantial question of law. So let us begin with number 1.
Whether the unregistered document dated on 8/3/2010 made in between appellant and respondent has complete law to certain.
Yes.
Now, my content here in the case is that even it is unregistered, but it can be used as a piece of evidence. Piece of evidence.
Yes.
A document which is unregistered does not mean he has no entirety of the credential of the document. So here we have placed it, that ruling also before. But it was not taken into consideration. That's why I have brought it into the substantial question of law. Now, if they agree, then there will not be any dispute. Then there will not be a substantial question. When he is disputing it, to decide the subject, it becomes a substantial question. Law.
Yes.
That is unregistered document. And here in the second appeal also, I have filed for additional filing of additional document under order 41, rule 27. There is no any such part. Even after seeing of this document, the appellate.
Why you are unregistered document was not taken into consideration by the trial court?
No, it was not produced. It was not
Produced.
produced.
Then if it was not produced, then how the court would have taken cognizance of your unregistered document?
No, it was
And,
found
and how does that question comes up before this court? When the document itself was not produced before the court below?
in the appellate court.
Huh?
Appellate court.
Appellate court?
Yes. This is second, first appellate court.
In the trial court, did you not produce this
No,
document?
Trial court. it
Mr.
was-
Tama, where is that,
It was
that
not.
he produced this?
Kindly come to my affidavit. in the
And
form
then
of
he had
opposition.
approached this court also? Page number,
Page number 66,
affidavit filed by,
written objection, affidavit in opposition in the form of written objection. Page number 66.
okay.
Yeah.
Page number 66.
Paragraph 4 onwards. Dependent has filed this application for allowing her to file an additional document, that is photocopy of deed of simple mortgage dated executed by plaintiff on 8/3/2010.
Mr. Pertin, come to page 66 of his affidavit in opposition.
Yes,
It is there.
yes.
Okay,
It was Xerox. Who have produced Xerox?
There was no question of Xerox and all.
No, no,
The case
yeah.
of the applicant,
Okay.
kindly then lastly come to the operative portion.
Hmm.
After giving so many regions and citation,
The same document was given two times. One was Xerox first. And the original one was after judgment.
It was rejected,
rejected,
Yeah,
page
and-
72,
yes.
paragraph 17. In the light of above, this court is of the view that dependent could not show any good cause for belated production of the said mortgage deed. Furthermore, if the dependent is allowed to adduce the said document, then trial has to be commenced from the stage of documentation and issues.
Is that wrong?
As there was no whisper of the execution of said document in the written statement and list of documents.
Oh.
This was not a pleaded case.
Hmm.
So no issues were framed with regard to the execution of said document, and as such, allowing the instant application at the stage of final argument will delay the trial, which in turn may cause prejudice to the plaintiff.
All right.
Lastly, paragraph 20, in the result and for the foregoing results, the instant IA is dismissed without cause. Now kindly come to the order passed by this honorable court.
Yes,
Next, page 74 onwards. Page 78, paragraph 14. This is by this honorable court.
yes.
Therefore, the impugned order to the considered opinion this court suffers from no manifest illegality or impropriety so as to invoke the jurisdiction of this court under section 115 of the Code of Civil Procedure.
Hmm.
In holding so, we derive authority from a decision of Honorable Supreme Court in the case of so and so reported in so and so, wherein it was held that documents were neither part of pleading in suit in question nor was in issue framed regarding said documents. We are afraid that we cannot adjudicate it on the issue pertaining to the said documents.
Okay.
Further, suits are decided on the basis of pleadings and issues framed, and the parties to the suit cannot be permitted to travel beyond the pleading. In the result, I find no merit in this petition, and accordingly the same stands dismissed. The parties have to get their own course.
Okay,
So that order of the learned trial court that was put to challenge before this honorable court in CRP number 15 of 2020.
all right, all right. Now. All right. Then let us come to issue number 2.
Now, it was brought into the court under order.
So issue number,
Rule
question,
Rule 8. It was brought. Now, while the original was found, I have made an appeal. Before the.
Kindly taken note, this order of this honorable court, they have never put to challenge before any higher.
Second. No. So, in my petition, 32, page 32. Come to the page 32.
Yes. 32.
Appeal petition.
Yes.
Issue number 2. Whether adducing additional evidence by the defendant appellate at this stage is permissible. This question I raised before the appellate court.
Hmm.
I raised it. That is under order 41, rule 27. I have raised it. Because there are two steps. One is during the trial stage, and one is after judgment of the steps. So during the trial, order 1, rule 8, we can go for the additional basis. But after judgment, when we come to the appeal, we can approach to the court under order 41, rule 27 of CPC. So what my contention is that the order and judgment which has passed under order 1, rule 8 will not debar to admit that document under order 41, rule 27. Because it is different steps. That will never bar.
Yes.
And on the basis of the judgment, light of the judgment of CGM as well as the High Court order, we cannot be debarred to file the additional document under order 41, rule 27. Because it was not taken into different steps. Different provision is different steps.
Yes.
Well, issue number. Huh? Huh? Now, 2. Whether a witness, Sri Balamu, DW4, can be allowed to give evidence contrary to the content of document, e.g. agreement dated 10/8/2010, executed in between the appellant and Sri Balamu. Now, here the contention is that their contention is that Tawatakar has not been made as party because it is not enforceable. But had Tawatakar been paid that amount, this agreement was not supposed to come. When he has declined to repay the money, then in that case, the liability goes to the appellant, and for that, he repaid the money. If that amount is to be paid by the Tawatakar, then I will not have any responsibility. I will not have any liability. So since he has not paid for that, since his name is not there, he is not liable. He is not enforceable according to that. But when you take the content of the agreement, you will find that he is the person who took the loan. Now, as I have clearly read out and given the term and condition written in the agreement, but when Balamu came to the court, he has deposed that this money was not taken by Tawatakar. This money was taken by Techimania. So how he can say whether it would be allowed can it be possible? But while writing the judgment, the entire report deposition made by Balamu was taken into consideration without taking into the consideration upon the term and conditions of that agreement.
Yes,
Now I have placed the ruling and almost here is also one more ruling.
no, let us see your first decision.
Huh?
First decision you have not placed.
Huh?
You said this is one more. You said this is one more decision.
One more decision.
Yes, let us, you have not, you are yet to place the first decision. Then we will come to your one more decision. Yes,
Huh? Huh? First, I have handed over one.
you have just handed me over.
Huh?
Which paragraph?
Huh? Para. Perangka. R square. Yalah. Huh? Huh? That is seven, para seven. Para seven. Here it is clearly written that section 92.
Which decision? Which decision?
Huh?
Which decision?
Uh,
Bandari Construction Company.
No. You see Utpadan Mandi Samiti, Sawan district, there is 2004. There is another. Once I have handed over, I handed over. That one is for that a person cannot give any evidence and deport against the written term and condition. Written term and condition.
Mr. Davi, your senior is relying on how many decisions?
6 to 7 judgment.
Huh?
6 to 7 judgment.
6 to 7.
Yes.
Which is the first judgment? I have been handed over with Bandari Construction and Amarjit Singh. There's no Upadhyay, something like that, what he said.
Corollary sama. Huh? Corollary. Corollary. Mana yang bicara?
No, okay.
You can, if you want to have a relook, you may have a relook. These are the two, yes.
This one, I have had a word, this is Bandari Construction Co versus Narayan Gopal Upate. Yeah, that I have handed over. Then another is the 2004, volume 2, HCC 283. Here, in the volume here, section 92 and 115 held preclude a party from leading evidence contrary to the terms of the written document. Written document. Because whatever Balawu has deposed, he has deposed completely contrary to the term and conditions of the agreement. And that whatever he had deposed, that has been taken into consideration. But the term and condition was a written between apparent in Balawu was not taken into the consideration.
Yes,
So since
you are handing over a copy to me or you want me to note it down?
Huh?
Which decision?
this I have, this I have,
Yes,
and another this one,
no,
extra I have not brought it.
one by one. Yes. This is which decision? Krishi Utpadan,
Huh.
Monday, 2004 to SCC.
Huh.
Which paragraph?
Paragraph 7.
7. Okay.
7.
Let us read.
Paragraph 7.
And this is for what proposition?
Huh?
This decision is for what proposition of law?
This that as per section 92 of Indian Evidence Act.
We are on the
Balawu.
question that yes, witness cannot depose against the terms and conditions of the agreement.
Yes.
Okay, yes. Paragraph 7.
Paragraph 7, but and from last it is nine sentence. Section 92 of the Evidence Act precludes a party from leading evidence contrary to the terms of the written document. Written document. It was therefore not open to the respondent to ask that even though he says it showed a price of 15.40 per square yard, the real market value of rupees 120 per square yard, to permit a party.
Okay, all right.
So here it becomes very important because Balawu what he has deposed is not contrary to the agreement, and whatever he has declared that was taken into consideration while giving the whole person the judgment.
And the judgment of the trial court as well as the first appellate court is based on the deposition of DW4 Balawu.
The appellate court just upheld that judgment given by the
Trial court, which is based on the deposition of the DW4 Balawu, isn't it?
Yes.
Okay. Contrary to the written documents.
Yes.
Okay.
Correct. Additional documentation. Additional document. Yeah.
Yes,
Yes, now. Next issue, next substantial question of law is whether the application to adduce additional document under Order 8, Rule 1A of 3, bar the parties to file application under Order 241, Rule 27, additional evidence at appellate stage to bring in record additional document.
this is which question?
Huh?
This is which question?
Uh,
Question number?
page 16, page 16.
No, page 3 is the questions framed by you.
Huh?
Page 3 of the additional affidavit.
Mm.
You have only 3 questions. Two and 3 are the one and the same.
Now, as per the order passed on this, we have been limited. Here, order is that for paragraph 19 of the memo of appeal, let material particular such as description of the unregistered document mentioned in the serial number 1. The term and condition of the agreement mentioned in serial number 2. Document executed between the parties mentioned in serial number 3. And the agreement and document mentioned in serial number 5. Now, these are to clarify the materials, the description of the document. On the basis of that, I have described in the additional,
Yes, on the basis of that.
on the basis of this order.
On the basis of that order,
Yes.
you have filed an additional affidavit
Huh.
formulating a substantial questions of law,
Huh.
3 in number, thereby giving the material particulars of the documents,
Huh.
which is at page 3 of your additional affidavit.
Page, um, and this is only to clarify, this document has been filed, only to clarify term and condition, which has been directed by the court. Now, other is this other substantial question of law has not been drawn up.
Davi, how many questions we have formulated?
Promoted. In our petition 87, only 3 were directed to be corrected,
See-
others were related from main petition. Other substantial question.
See,
Our condition is that we have been directed to.
altogether, how many?
Now it's 6.
See, this court was under impression that with your additional affidavit, you have reformulated your substantial question of law, which is only 3 in numbers.
Three in to this
But-
additional affidavit and others were related to main RSS.
Okay, altogether how many? Altogether how many?
5. 3 from additional affidavit and others from.
Had Mr. M. Patil, learned counsel for the senior counsel for the appellant. And Mr. K. Tama, learned counsel for the respondent. There's no other way, we have to adjourn the matter, Mr. Patil. We have to adjourn the matter.
The time is up.
I thought we were concluding. One, I have heard unregistered document. Now the second question, that whether the witness can depose against the written agreement. That hearing was going on. And question number 3 is the same. I thought we are concluding the, since you have other substantial questions of law, which was originally submitted, we'll hear it some other day. Also, on the prayer council for the parties, listed after vacation.
And now, during financial sector, what
Ah.
my country said, it's supposed to maybe matter. Because
Okay.
other parties taking the advantage.
If status quo order was vacated, then how can we again pass a status quo order?
Status quo is neither in favor nor our favor.
The status,
Then the vacating of status quo means you are giving them the RTO filing without filing of education. Degree of education.
no, he had filed a application for vacation of the
Yes, let
status
them
quo
file.
order.
If there is any dispute
My
about
lord,
making of-
undisputedly, the land is under my possession.
No, whatever it is, we are not.
Ha, They are
but-
also
but
not
some order
disputing.
was passed on, after hearing both the sides.
And now they have a remedy to challenge that order, but then they are not doing that also.
Fine.
So that will be review of that order. That was
It will amount to review of the order,
review of the order. my lord.
vacating the status quo order. Is not it? It was passed after hearing you.
Highly
After-
prosper.
We'll take it after vacation. Okay.
Next day. After,
Immediately after vacation.
huh?
Immediately after vacation.
Immediately after vacation.
You want to fix that?
No, no,
We'll give you a fix that. 6th of November. That is the first day, first day of reopening after vacation.
After, okay.
6th of November is okay.
After vacation.
Okay, don't fix it there after vacation.
Number 7 and 8.
Yes.
My lord, I am representing this item number 8 and my learned friend is item number 7. Is almost similar. Item number 7, there are different accused. Now, my lord, we challenge the complaint which was filed by the prosecution before the learned trial court. And we say before this court that this complaint is not at all maintainable in view that there is a prosecution, if your lordship kindly see at page 30, at page 31,
Yes, Mr. Kato, after vacation?
let it be in the month of, my lord, December, my lord. Because this anyhow, they are taking instruction about, there is nothing on the law points. Law points, so in the month of December, any date your lordship can fix it.
After vacation or December?
That is the December, my lord, is convenient by line.
My lord, subject to-
From Calcutta.
We'll say after vacation, November. You're in the beginning of beginning of October.
No, December, I think 6th of December, my lord, if it is not inconvenient, my lord, David,
No,
by
but-
that time, he will take the instruction, my lord.
but this,
Well, subject to convenience on the part of the senior council.
Oh.
Or I mean, every day here, madam. Even if it is fixed.
no, he is proposing for December. What do you say? If you have no objection.
For
to
me,
it,
no objection, madam.
Okay, all right.
Yes, but only one thing they will get, my lord, instruction from the government, from the department. Whether if admissive action is taken, where is the question of filing a prosecution, my lord, that he will take the permission. Because clearly they have written, my lord, kindly see page 31, your lordship will adjourn.
All right, I have Mr.
Yeah.
B. Das Senior Counsel for the petition. You are appearing in one case,
In item number 8,
petitioner in,
item number 8,
and Mr.
he is Mr.
Item number 7,
7.
and Mr. Your good name?
And for the
employees
of the company.
He is K Das, Mr. K Das.
K. Das, okay, K. Das, learned counsel for the petition in item number 7. As well as Mr. D. M. Kato.
For all respondents, madam.
Learned? Standing counsel? No,
No, madam, Union of India, madam.
okay. Learned
Ah,
DSGY.
DSG, madam.
GSY representing the Union of India. As prayed for by the learned council, appearing for the parties listed in the month of December.
Yes. That is 11th of December, my lord.
Okay, 11th of December. 11th of December. On which date, Mr. Kato, learned DSJ shall place before this court the instruction received by him. What kind of instruction?
My lord,
Who is-
my lord, I will tell your lordship.
Subject to correction, my lord, my lord, instruction is not required, I thought, madam. As because it will be, it is basically on the law point, my lord.
No, he has taken instruction, that's why.
Okay,
He has sought for instruction.
My-
Hold on. Don't write it. As per the rule and the council appeal for the parties, listed on 11th of December.
Interim,
Interim
there is
order.
an interim order passed.
Interim order passed earlier shall continue till the next date of listing.
Madam. Blah, blah.
My lord, this case is actually, they ought not to have filed this prosecution. They ought not to have filed prosecution because already administrative action has already been taken. So for a moment, kindly see at page 31, for a moment, my lord, sorry for troubling. See
Yes.
page 31, my lord, for 1 second. page
Item
31.
8.
Item 8, see page 31, my item 8, my lord. What they have done, my lord. 31 kindly be seen, my lord. 31, they sought for prosecution sanction at page 30 for filing this complaint. Page 30, my lord,
Yes.
you got it?
Yes,
30, and kindly see 31, my lord, last paragraph.
yes.
Last paragraph, it is therefore requested to examine the above matter in the light of the facts of the case and guidelines for taking action on sample of drugs as declared not of standard of quality and advise this office as to whether administrative action is recommended against the manufacturer by concerned SLA. SLA means the state licensing authority, or prosecution is to be launched against the manufacturer under Drugs and Cosmetic Act 1940. In case prosecution is to be launched against the manufacturer, necessary special permission may be accorded to this office since the incident took place as so and so, and as of now it falls under so and so. Now there are two things. One is, if you have taken administrative action, my lord, there is no question of prosecution. Or now kindly see the administrative action has already been taken. 26, kindly see. 26 has already been taken. Already taken. 22nd kindly be stated, see, my lord. Kindly see page 26.
26. Yes.
26 kindly see, my lord. This administrative action has already been taken at page 26. Now this SOCOS has been issued at 28/12/2017. Lordship kindly see. Now in excess of power conferred under so and so rule frame, under farm is asked to appear and all relevant document for personal hearing. any. So now in pursuance to that, we appeared at page 27. Kindly see 27, my lord.
Yes.
We appear at page 27. This is 9/1/2018. This is an order. Now in exercise of power conferred upon director so and so, last paragraph, for the purpose of 84 so and so, under the farm is the order that the farm is strongly warned. Further occurrence of such violence be seriously dealt with. So this already they have taken the action. Please do not do in near future. Now kindly see at page, next page, my lord, page 32, 28. Already we have given undertaking at page 28. We have received the above mentioned memo and noted the contents. As you are asked to take the corrective action and preventive action against the product so and so, please be informed that we always take precautionary measure each and every step of manufacturing for all of our product. However, as we mentioned, we will be more careful during manufacturing so that no such incident occur in future. So already administrative action has been taken. We already have taken compliance of it. So where is the question of my prosecution? Again, started at page 31. That is why I have shown before Lordship. Either you take administrative or a prosecution. Already they have taken administrative action, my lord.
All right, we'll consider.
Yes, my, that's very important, my lord.
Lordship, I'm accepting that, submission from my senior counsel. Just one thing. I want to say that the drug inspector ordinarily got the permission from the authority council. Now, just I will show just 2 pages only. One kindly also come to page number 31.
Yes.
India seek permission from the Drug Controller General India.
Yes. Yes.
The letter was dated 8 February 2018.
Yes.
And Lordship kindly come to page number 27.
Yes.
It's an order passed by SLA, State Licensing Authority.
Hmm.
Now let's see, kindly come to page number 31. The last paragraph.
Yes.
It is therefore requested to examine the above matter in the light of the facts of the case and guidelines for taking action of the samples of drugs as declared not of standard quality. And advise this office as to whether administrative action is recommended against the manufacturer by concerned SLA or prosecution is to be launched against the manufacturer under Drug and Cosmetic Act 1940. Okay. Now kindly see the date. Date of the order. Can you see the date of the order also? Page number 27. It's 18/12/17. The SLA already passed the order. Thereafter, on 8 February 2018, the Drugs Controller seeking permission to prosecute. See, he is asking whether I have to prosecute or I have to report the matter to SLA or seek direct SLA to take action.
All right, we'll consider on the next step. Yes.
I can, interim order board case will continue.
Yes.
Yes.
The item 12 may be fixed tomorrow. Will.
Leftover, we'll take it up tomorrow. All methods. Which one? Item number 11. Okay. But item number 9, 10 are waiting.
8 and 9 and 10, maybe on 11.
Oh, 9 and 10, 11.
9 is wrongly taken with item number 10.
Okay.
This wrongly take.
Then what? We'll segregate it.
Yes.
There's no, there must have been an order to list it together.
No,
my lord, it was
There's a
supposed to be
order wrongly.
listed after 4 weeks, ma'am.
Let us see. 9 and 10, huh?
Both are two different matter, my lord. Wrong.
You see,
Yes, my lord, I have seen, my lord.
there is an order. That's why it has been listed
There's
together.
a order, my lord, that's why.
Huh? It has been wrong. Order is according to you incorrect.
No, my lord, because my lord, it was supposed to list with item number 12, but
But whatever it is, we'll pass an order on that day.
yes,
We can't segregate it today, since there is already an order
they did on 11. you know.
on 11. Okay. 9 and 10, na? On the prayer of Mr. S.K. Deori, learned counsel for the petitioner with the consent of all father, learned standing counsel SIC,
My lord.
listed on 11th. Yes, you are 11.
Is item number 16 and 17, my lord.
Hmm.
Since there is a IA for
Hmm.
vacation of interim order,
Hmm.
so considering that urgency, kindly matter have listed upon 5th, Thursday,
Thursday.
my lord.
Okay, 16 and 17 on the
16
prayer
and
of Mr. K. Tama. The counsel for the petitioner listed on 5th.
5th, my lord. Highly obliged.
Day after tomorrow.
Day after tomorrow.
Okay, all right.
Number 11, my lord.
Okay, yes, call item number 11.
But here the petitioner, my lord, in the transit case, my lord, the petitioner is in custody since